Hello, my name is Kenneth Kahn. I'm a criminal defense lawyer and I've represented people charged with DUII for the better part of over 22 years. If you've been charged with a DUII, let me first explain what the charge means and what you should be doing next. If you're like most people, you're confused about how to handle your case, and you might feel a little bit overwhelmed by the amount of paperwork that you've been given by the police or the courts and just what that paperwork means. A DUII means driving under the influence of intoxicants. An intoxicant can be alcohol, it can be drugs, or a combination of alcohol or drugs. There are really two parts to a DUII case. The first part is the license suspension. The second part is the criminal charge of DUII. Let's talk about the license suspension. The license suspension occurs if you've failed a breath test, if you've refused a breath test, or if you've refused a urine or blood test. Independent of the license suspension is the criminal charge of DUII. You have a right to challenge the license suspension from a breath test failure or refusal, or urine or blood test refusal, by asking for a DMV hearing. The request for a DMV hearing must occur within 10 days of the date of your arrest. If you don't make the request, your license suspension will take effect automatically 30 days after the date of your arrest. Take a look at your paperwork. There's something called the Implied Consent Combined Report. It's a large yellow piece of paper that's about 8.5 by 14 inches. It says if you are going to be receiving a license suspension or not. And there's also a place that makes that document your temporary driver's license for the next 30 days from the date of your arrest. If you haven't already done so, find the Implied Consent Combined Report and sign it. That is your driver's license for the next 30 days. Independent of the DMV hearing process and your ability to challenge the license suspension is the criminal charge of DUII. You'll be going to court shortly. You'll need to know where to appear, when to appear, where to park, and be sure to give yourself time to get through security and to find the courtroom. Once you get to court, you're going to be wanting to enter a plea of not guilty. A not guilty charge means that your case has not been proven in court. Under our system of justice, you're innocent unless or until you are proven guilty in court. The worst thing you could do is to plead guilty as soon as you go to court, because you give up all of the advantages and protections of the legal system, including your eligibility for diversion. You may have heard from friends or family, or even from talking to other attorneys, about the diversion program. Diversion is an alternative to taking your case to trial. It gets its name by what happens to your case. It's diverted away from the trial courts for a year. During that time, you undergo an alcohol evaluation, treatment program, and there's other terms and conditions that you have to abide by. Once you successfully complete the diversion program at the end of a year, your case is dismissed. The program is like a carrot and a stick. The carrot is the dismissal of your charge. The stick is a failure to abide by the court's conditions during the diversion program. If you fail to successfully complete the program, then a conviction is entered against you and you face jail time, an additional license suspension, fines, fees, assessments, probation, and more. To be eligible for the diversion program, you have to meet the requirements. First, you can't have been convicted in this state or any other state of DUII in the last 15 years. Second, you can't have participated in an alcohol or drug treatment program in this state or any other state in the last 15 years. Next, the current offense cannot involve an accident injury to anyone other than yourself. No other charge of DUII can be currently pending against you. You can't have been convicted of murder, manslaughter, or assault with a motor vehicle. And you can't have been operating a commercial motor vehicle or possess a valid commercial driver's license. If you meet the eligibility requirements for diversion, there are still a number of court appearances that need to be taken care of, additional paperwork, and reports to obtain. If you're not eligible for the diversion program, or if you don't want to go through the diversion program, you still have other options, including the right to a trial. You also have the right to challenge the admissibility of any evidence against you, such as breath test results, breath test refusals, whether or not your stop was legal, whether or not the arrest was legal, whether or not statements that were made can be used against you, and whether or not the field sobriety tests were properly performed. Those are just some of your rights when you're charged with a DUII. Although it can be overwhelming to think about the case, and it may be that the charge has interfered with your happiness, or that you're not sleeping as well as you'd like to because you're worried about the consequences of the case, I can promise you that it's not as bad as you think it is, and that any number of people would gladly trade what happened to them to be in your shoes. For example, there was a police officer in the city of Portland who was operating a marked patrol vehicle on duty, displaying his badge and in uniform when he ran over a bicyclist in his patrol car. His blood alcohol was a .16. He would gladly trade what happened to him for your position. Just so, there was a sitting Washington State Supreme Court justice who was charged with DUII, hit and run, and reckless driving while she was a justice on the Supreme Court. Finally, there was a girl in Lake Oswego who had been accepted into Stanford. She crossed over the line, killed the oncoming driver. Her life will never be the same because of that. Any of those people would gladly trade their circumstances for yours. In the short term, there's a lot to take care of. If you'd like to discuss your case or to request a DMV hearing, I'd be happy to do that for you. All you need to do is give me a call at 503-241-4105, and we can talk about that. Also, you need to start preparing for court. There's a lot you can do in terms of getting paperwork together, such as receipts for any drinks that you've consumed or names of people you were with that evening, and start taking an active role in preparing for meeting the challenges that are ahead of you. If you'd like my assistance in the case, I'd be happy to talk to you about additional options. Thank you for your attention and best wishes on the successful resolution of your case.